So, as at onset, a very good morning to all of you, and thank you so much for being part of this on Sunday. I know it's a lot of it's an ask for you guys as a student to come to be present online on Sunday. So I really appreciate it. Now, before I go on to introduce, I think the speaker for today, Afzal Badr Khan, has already delivered one session, so I'm not going to reiterate the introduction. But just to kind of lay a structural layout for today, we'll be continuing, and this is our second lecture series on the on the oral arguments and courtroom mannerism. That is a title of what we did last, or what Asad did yesterday, and what Afzal is going to continue and deliberate upon. Now, before I pass on the show to us, Afzal, and he's going to run the show on his own, I just thought that it is also a good time to revisit some of the reflections that I took away from Asad's lecture yesterday. And I thought that maybe as a starting point, at least have a small dialogue over what Asad stated and what could be some of the possible strands for us to continue that conversation. So, I'm gonna share my screen. Do let me know if you can see it. Okay, is it visible? If somebody could quickly confirm. Okay, I received yes. Great. Thank you so much, Meenal. Appreciate it. So these were, yeah. I'm gonna start with what Asad left us, and Asad's conversation had one central premise, and that is that when you are narrating or when you are pleading in front of the panel of judge, it is an onus upon you to engage and not narrate. Now, I was wondering and reflecting about some of the aspects as to how do we facilitate our students to or empower them with this toolkit as to how does one should appear and how does one should engage when there is already a stipulated timeline. There is a constraint, theoretical, conceptual, jurisprudential constraint because of the moot proposition. Now, one of the things, and I'm also talking from a very personal experience, is when you are, and considering that you have only 15 to 20 odd minutes, one of the first way, or one of when Asad was talking about that you should prepare a speech, I do completely concur with that aspect of him, because the reason as to why speech becomes important, because speak also allows you to think whether your communicative language is something that can be comprehended by the person who's hearing it for the very first time and who is going to be evaluating you on that particular aspect. So it becomes important, and I think it is one of those central premise as well, that you should express your case in the simplest language if possible. Now, this might sound a bit of technical or a bit of hackneyed way of putting it across, but think about it. It is a task which is easier said than done, because some of the arguments and some of the questions of law that you will be deliberating upon would require that level of complexity, would require that level of jargonish lingua culture. So it is a onus upon you to express them as simply as possible. Your expression will appeal to the majority of people. Like, for instance, I just took an example, like to begin the simple case, start with a very short and concise statement of the crux of your submission, the pith and essence of what you are going to submit. Like, since many of you are experienced with at least the contractual law aspect of it, so I just thought that this example would be something that is more relatable. Like, for instance, the opening premise can be something like the appellant has suffered loss because of the respondent's wrongful avoidance of the contract. This is a very strong opening, because it also leaves the audience, and in the case of competition, that audience is your panel of judges, in no ambiguity. They are sure about the direction of your submission. They at least know the route on which you will be branching out. And for just a matter of comic relief, think about it. Sonali ma'am, can you keep on admitting the people? It seems a little bit of disorienting to keep seeing them on the screen. Like for instance, I just thought that, just to add a Sunday comic relief, think about it. Like, think there has been a so how I don't know. Is there a way of getting a raise of hand? How many of you know Sashi Tharoor? So let's say I can see Rishika raised hand. Now there has been like many of you are raising hands. So think about it. There is a lot of what do you call mimicry, a lot of imitation on his lingua culture. The reason is one of the reason is because it is not something that we are taught. It is not something which is very easily comprehensible to our ears. It might sound pleasing to our ears because of the fancy languages. Like for instance, I just used a meme, something that I'm kind of recently being acquainted with. Like for instance, Arnab Goswami. I hope your judge does not turn out to be Arnab Goswami. But think about it: if a judge wants to ask, the nation wants to know, and you have a response which contains all the jargonish language, and some of these jargonish language I don't even know the pronunciation of, so I'm not gonna even try. But that is a point when you lose that level of engagement with your panel. It might sound a very technical aspect, but think about it that your communication is not able to reach to them, your arguments are not able to reach to them. You might later conclude, or you might later say that they are not skilled enough to engage with you, or they don't have that level of intellectual acumen to engage with you. But maybe in the moot court competition, you have that constraint that one of the premise is that out to be reaching to them. So that's a onus on you, and that's a very heavy onus, because sometimes, as most of you will be aware, that legal lingua culture has a very different vocabulary. So one aspect that I thought, one reflection that I thought we should be taking about is that maybe it is good time when you are preparing your speech, it will allow you to think whether your speech or whether the strand of your arguments are comprehensible to the widest majority of people or panel that is going to be there. The second, and I think I should not be killing a lot of time because, I was asked to moderate, but me being a lecturer, I thought that, yeah, let's just take this opportunity. Use signposting. Now, this is a very practical and pragmatic. I was while browsing through Asad's presentation, I think some of some of his arguments, or some of things that he wanted us to think or reflect about, required that there should be a signposting. It's a very pragmatic approach while participating in the moot court competition. Like for instance, I've taken one example, and it's a directly copy paste from some textbook. Like for instance, the speech that I took has a cue which says, on behalf of the appellant, I will be addressing the wrongful avoidance of the contract, and my co-counsel will address the entitled to damages. Now, what the person does over here, he provides a structural outline on the issues that he or she will be addressing and the co-counsel will be addressing. Again, the second aspect, the second part of it, the appellant submissions on wrongful avoidance are made in three parts. Now, signposting is basically nothing but to allow an audience to have outline of your argument, and is a very effective tool of moot court, considering that there is a stipulated timeline and avenues for explaining yourself are way too restricted. Just the last point, and I think Asad Afzal would be in a better position to deliberate upon this point, but I would like to hear as to what he has to say and what he has to offer. One of the best practices is to also provide or to also address alternative submission. Now, the alternative submission aspect does not only render richness or theoretical richness or conceptual richness to your argument, but uh, it also it also allows the panel to see what can be the alternative scenario. One thing that you have to take along with you is, and I'm just going to stop with this, as the saying goes, that all road leads to Rome. Now, this is your onus, that What you should, the story that you are narrating or the engagement that you are doing, you have to make sure that you're telling your audience it does not really matter which path you take, you will end up at my conclusion. I know there's a lot of strong assertion and aggressiveness in this particular line, but I also would like you to think with this, at least with regard to a hypothetical situation or with regard to moot court simulations. There is a blindness of ignorance that you ought to do when you are presenting and when you are pleading, that no matter what alternative submissions there are, my version of story or my version of narration is a more persuasive one. And if you are able to achieve that pedestal, I think that is one of the reasons, or one of the ways in which you can have a very persuasive story to convince the panel of judges. So I am going to uh, pass a baton to Afzal from this front. Afzal, I don't think I would like to introduce you. If you would, yeah, if you would like to say a few word about your lived experiences, I think that's your stage to kill now. Thank you so much. I'll be taking all the questions. I think there are a couple of them. Once Afzal completes his part, and then we can both have a small conversation on some of the questions that the students raised. Afzal, over to you. I'll stop sharing my screen and yeah.
Thank you so much, Aditya. I think that was very helpful, and I'll take up the points that you just suggested, including making the alternative submissions. So, to begin with, hello everyone, and a very good morning. So, why is this introduction important? I could have skipped the hello part because I can't see half of the screens, yet I start a conversation. That's effectively quote mannerism. That's mannerism in its simplest. Now, when you take a conversation forward in a one-to-one scenario, uh, you have certain sense of decorums and certain set of boundaries with your friends, with your closer friends, with colleagues, with professionals, with teachers. There are like different boundaries you set, and those boundaries are what you respect for the other. Those boundaries are what you involve in your discussions. There are certain set of terms that become very commonplace. Bhai, those. For colleagues, it will be a different professional approach to this. When you consider what happens in a courtroom, or what is the setup in a what is the setup in a moot court, rather, take it in a manner that is the utmost professionalism that you show. That's where you show your creamy layer. That's where you show you the best side of you, and anything that you present, treat it as holy, because whatever you shoot for, you'll fall shorter than holy at the very least. So try to set up the utmost boundary when you think about the code mannerism. Try to do the utmost that is possible, because whatever you do may still come short, but then that will still be the best that you can offer. Now, that doesn't mean that you sanctify a judge to a point where you hesitate in even delivering your point. That's not the point. Respect and opinions don't have to surrender to each other. So, before I start with what I think of court mannerisms, or what my take on it has been, because I've argued few matters before court. So, how I go about it, or what has been my experience. And I've done a fair bit of moot courts. So now, why I would think is, before coming as to what it is, I would think, why is this relevant, as to what is the entire point of calling somebody your lordship, your honor, and all these exaggerations that we do in our practice. For instance, in my personal experience, when I initially started practice, I was told, never leave a courtroom with your back towards the judge. It's disrespectful. And that's the same thing I was told when I was entering Nizamuddin Dargah. Never show your back to the shrine. So I was amused at this level of sanctity for a person. But then I also forget that it's this level of sanctity is not for the person. It's for the position that that person holds. It's for the seat that has taken so many years, and it is the seat that delivers such an important task as justice. So a fair bit of respect doesn't hurt anybody. And come and bringing it back to why this conversation is important for moot courts. because this allows, as I started in my, I'm not sure how many of you were there in the previous lecture, but mooting is not about mooting alone. It's about taking a skill that has a role in your profession, that has a role in your real life. This conversation with a judge is a conversation that you ought to have, albeit switch the terms. Instead of your lordship, refer to your judge, your teachers as sir and ma'am. And the conversation should be on the similar scale, where you present your point, in how much time you present your concerns to your teachers or your colleagues in any discussion or in a debate, where you put it forward and then address the responses. So the idea behind mooting is not to, you know, uh, become a superstar in mooting alone. I'm sure if that is the goal, then perfectly fine, and that's set your targets very high. But for anybody, I would say anybody who's starting and anybody who's inclined, I would suggest that this, again, mooting as well as court mannerism, is all about inculcating certain skill set about yourself, about how you go about your regular activities. Now, setting up a scenario, in a moot court, you have about 10-15 minutes, and you have to make a point, you have to complete a script of submissions, and also at the same time dodge a volley of questions that the judges will throw at you. Some of them may not even throw at you, and that's not even a good thing, that the judges aren't asking a question. So there are different set of scenarios, unpredictable scenarios, because you never know who's judging a moot. How many judges are there? How many kinds of judges are there? There may be a Shashi Tharoor, there may be a Arnab Goswami, there may be Aditya. So there may be a different set of judges, and each have a different take on a question. None of them is good or bad, it's just a different take. So in those unpredictable situations, how is it that you deal, how is it that you cope, is an important skill set that has numerous applications. In a small confines, as a company office, if you're a legal associate there, you have to put your point as to why the company is in trouble, and you have to tell it to the highest clients of the company. It may be the MD, it may be a small manager, but you have to explain your point in a certain amount of time with certain amount of clarity and utmost amount of professionalism, and that is where court mannerism comes in. Tomorrow you can switch court mannerism, the word court, and use it for office mannerisms. The principles would still be similar. So taking this forward, this is what I think the concept or the aspect of courtroom mannerism has a role in day-to-day life, and that's how you inculcate certain approaches which help you in all fields, all forms of life, all forms of profession. So now, taking it forward, I understand Asad has taken some very crucial aspects already forward. So I may overlap, so forgive me for that, but I would still try to cover whatever I think is relevant. So the first things first is that whenever you have a conversation about court mannerisms, the first thing that is indispensable is respect. As I started, it's not the respect for the person alone, it's the respect for the seat and the authority that that person commands. So in all conversations, it is always of utmost importance that you deliver the certain amount of respects. And as to how it helps you in moot, there are certain number of points allocated for the presentation and the manner in which you conduct yourself, even disregarding what your substantial arguments and substantial performance is. If you're disrespectful, if you're not cautious about how you go about a conversation, then you're likely to lose a lot of points. So always address, if there are multiple judges, then we often refer to them as benches, or your honorable bench, or you ask permission from them whether they can be referred to by some term which you in your normal parlance refer to them as. And I can understand in conversation sometimes what happens is, instead of your lordship or your ladyship, you end up referring to them as sir and ma'am, which is perfectly fine. It's not that they don't expect it. uh, so long as they see a deliberate effort to recognize certain decorum, I don't think so it's offensive to anybody if you in colloquial terms, or the in a regular course of speech, you refer to them as sir and ma'am. That's perfectly fine. You don't have to correct yourself the moment you say sir. Oh, no, 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 your lordship, because that doesn't seem appealing, that doesn't seem necessary. An overcorrection is never warranted when it's such simpler terms. Because fundamentally, this brings me to my second point, it's always a conversation. No judge, or at least in at least any moot court, has come here to listen on and on to blank screens, or to speak to an audience that doesn't engage. So when you're at the dais, where you're required to present your points, it's not about running the entire script. Your script can take a back seat, and what is important is engaging. As Aditya also said, it's important to engage with the judge and present a side which is more palatable for the judge himself. Now, you may have done your majority of research on one aspect that doesn't seem to vibe with the judge. You can always have a backup argument, and that argument may resonate with the judge, and that's perfectly fine. Because in the end, what is required is not you delivering your whole set of speech. What is required is that you engage, you understand where the judge's ticks and talks lie, and then you modify your approach to deliver that best argument that is most palatable to the judge. And that may always be a hit and miss. That's perfectly fine. But point is that your attempt ought not to be a complete delivery of speech within, let's say, if I've been given for 15 minutes, I'm going to run this show for 15 minutes and I'm not going to pose any questions. That's not how a moot court should be. A moot court should have back and forth, and that back and forth is a skill that comes with time, that comes with multiple attempts, multiple practices and experiences. For instance, if this were an ordinary classroom, I would look at each one of you and ask, should I move forward? Is there a head nod? Thankfully, I have Sonali and Aditya helping me out, that I can recognize that this conversation is a two-way street. It's not me going on my own. That kind of engagement is required at a higher level in moot court, where you ask, Malad, if this point is sufficiently covered, do I have permission to move to the next point? If this issue has been sufficiently, let's say a question has been put to you, you've answered that question, then what do you do? Do you drone off on its own, or expect a follow-up question from the judge? So you ask, if there are no further questions, may I move on to the next issue? Because it's not about completing your script, it's all about engaging with the judge at the level where you're able to deliver your points in the most clearest form and the simplest form. Fancy jargons have never held a lot of communication from Shashi Tharoor. So the question always has to be is whether the audience is able to digest what you're giving. So moving on, um, it always happens in a moot court that a judge always speaks up when you're speaking, when you're delivering your speech. Now, at that point, it is of utmost importance that, out of respect, or out of the situation that you're in, that your script takes a back seat and the judge's questions take priority. So whenever a judge is addressing a question, never interrupt. No, 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 coming to that. I'm coming to that. You come to it when the judge asks. Whenever a question is addressed, the priority has to be to answer to that question. Now, here is a take on it. When a question is addressed to you, that may be something very dissimilar to what you were about to take up, your answer ought not to be that I'm just coming to it, because if you are coming to it, he's asking the question right now. So your question should be answered right there and then. So what you do at this point is you take the question, you take the submissions that you were inclined to make at a later stage, start with that, start with answering the question, and move the conversation back to, as I was saying, including this argument has already been covered in things that I'm just disclosing. So it's always an art how you swing about a conversation. Now, coming to this, because this is intrinsically linked with how you should prepare for a moot. Your moot preparation Some believe that entire speech should be written. Some believe there may be a set of notes. But that preparation, everything helps. And what is of utmost importance, that you have a map as to how you're going about. You should usually I have certain set of bullet points. In these bullet points, for instance, it's misrepresentation. I need to be certain that I refer to these ABCD factual instances. I make it a point that I need to refer to this particular case law which hits the nail on its head. So all these points should be not in extenso, should be in keywords, in a manner that you would like, in a series or order that you would like, should be with you, so that any given point, if a judge asks you point 8 when you're on point 5, then you know what is covered, and then you can come back to that point and you're sure that you've not missed anything. After all, months and months of research in a memo don't help anybody when you don't put it on the stage. And that's certain things, these are certain things that bite you in the end as well, that, oh, I wish I could have made this point. So let there be no regrets. And I can also understand that there is a time constraint given at any moment. So one way to go about it is dedicate time allotment to each of your argument. Recognize that these are arguments that are dispensable, and if should the time not permit, these arguments I will not take at all. But I will make a point to cover XYZ arguments, and these are my priority, no matter in what order they lie. So always have a structure, always allocate time to that structure, and always recognize that you may have to dispense of with some of the arguments in the structure. And that preparation ought not to happen at the dais, it ought to happen way before. That is a part of moot preparation, recognizing what is to be said, what can be dispensed with, what is an additional argument that may earn brownie points. You need to allocate time to each of them, and that is a part of rehearsal, that is a part of practice. And once you're so in tune with your moot problem and your proposition, it is up to you to identify what parts are relevant for you, and what case research or what research is something that is dispensable, that may not be required at this stage. And if you're able to deliver, well and good. If not, then it's not something that compromises your performance. So always have that structure in mind. A layout, speaker notes, call it whatever you want, is always something that you must carry in any moot problem. Then even if, as I said, even if there is some digressing from your structure, if a question comes, you keep taking, okay, this point is covered, this point is covered, okay, this point, because the judge asked a question, I have to move on to the later points. So always have that structure that helps you identify, even if you digressed, even if you're distracted at some point because of questions from the judge or taking forward an answer, you can come back to certain points that you think are relevant. There are, as I said, there are different kind of judges. You need to play yourself to the audience. Now, some judges are going to throw a volley of questions, which is always better than a silent judge, because you never know what's going on in their head. So it's always better to engage, as we started, as previously also discussed. It's always better to engage, but the skill lies in identifying which judge wants, what is it that each judge wants out of this moot. Some judges may have active questioning, which I think with time and practice you will develop a skill to answer, which is always better in my opinion. And there are some judges who do not engage. It is upon you to keep poking the bear to see if there is any question that comes out. It's okay if it doesn't, but at every point, if my lords have any question to the arguments that were covered under this head, I'd be happy to take them, or if I have permission, I can move forward. Always engage. If you read out a case law, if you point to a certain extract in your memo, then wait. It's not a race for you to start reading. It's pointless if the judge himself or herself is not at the page where you want them to be. So always come, whenever you're pointing to a certain extract, be patient, Let them, it's not about you running your time, it's about the judges getting whatever you're saying in that limited time. And it's not helpful for anybody if you drone off without even recognizing that the judges haven't even opened their memo. Always refer to the memo and any content compilation of cases, whatever. That helps the judges to, even the most resistant or most disinclined of the judges, if you engage them, they will throw you some bait, and that bait is what you take to engage with them. So always wait for them to open the compilation or the memo. Always engage with the memo. At page so and so, my submissions have been elaborated. However, to sum it up, this is what my contention lies. This is where my contentions and case laws lie. So you point out to the page. If they want to read, they'll mark it. If they don't want to read, they will at least pretend to look at it. But always a different engagement when you finger point that this is what I want you to read, because that allows you not to elaborate further than necessary. And if they are academically curious, they'll look at it and read it on their own. So that's always a good thing, that you keep engaging an eye contact and keep asking them to look at memo, so that they are constantly on their toes. I don't want to sit idle as a moot judge. I don't want to sit idle and stare at a face. I want to always be engaged as to what is required of me. Do you want me to ask questions? Yes, I will ask you questions. Do you want me to look at something? I'll look at it. But point is that you need to direct me to uh, wherever you want my attention to lie. And this is your show. You are running the performance. So it's upon you where you direct or you misdirect. And if you don't do anything at all, I may as well relax in my seat and throw a bunch of questions which may unnerve you, which may distract you. So always a good thing is when you anticipate there are too many questions, then the best way to engage a judge is, look, read this. He will be occupied in trying to read the extract and also hear you. So these are certain tricks and tips that you can inculcate, and also depends upon the audience. So um, as Aditya also referred to something called signposting. This is this is something that I agree that has a tremendous role in how you prepare for your moot. Now that may signposting means putting directions where you want the judges to lead. And as I said, key, the conclusion, no matter which path you take, the conclusion is where you'll end up favoring me. So it's always good to have signposting, in the sense that if misrepresentation or fraud, the element of fraud, has certain factors to it, lay down those factors, use those keywords, because that is what the judges are looking for, that you use the terms that are part of the moot problem, and you lay down breadcrumbs for the judges to grab and identify that, okay, you've understood the problem, you've understood what the moot court requires of you. So leave the breadcrumbs using the language, using, if for instance, if you research a case and you find some very good verbiage, you find out some very good phrases that you want the judges to know, let that not be in the memo alone. Use that in the in conversation. Misrepresentation has XYZ characteristics, and XYZ characteristics are fulfilled because if you look at this fact at page number so and so, it it leaves no doubt that there was an attempt to present something that I wasn't, or that the character wasn't, and thereafter I acted based on this representation is evident from page so and so. So leave the breadcrumbs, and always in your own map or speaker notes, have these signposts recognized, that when I'm talking about an argument and misrepresentation, I will use these terms. I have to in my conversation put forward these few terms, and when these terms are exhausted, I'll move on to the next issue. When these cases are covered, even in vague references, I'll move on to the next term. Um, now I'll take the aspect that Aditya said for alternative submissions, and that's really required for the very simple reason that a moot is about how you research, how you present a story, how you understand a story, and how you present a version of that story if you were one of the characters. That's what mooting is about, being a real life. And if I'm practicing as an advocate, then my story is not my own but my clients, and how I put it forward before a judge is what will win or make or break a case. So it's always important that you do not approach any case with a tunnel vision. For instance, if you identify this case is only about misrepresentation, I don't have to deal with fraud, but there's no harm in preparing, and an additional preparation is always that helps you learn. Your additional research may as well be a waste, but it helps you explore a topic which you wouldn't have ordinarily. And having alternative submissions give the judges something more to think about. Okay, if not this, then even this aspect allows me to, you know, come in favor of the performer. Now, there may not always be these alternative submissions. It's always good to be creative. It's always important to be creative, because that's what a mood asks of you. You find a solution to this. Sometimes the strangest of questions may form an interesting argument that were never the mood uh, drafters idea or intention. But that is where your skill set lies, in finding colorful ways to look at some standard problem which nobody else could have looked at. So it's always good to have alternate submissions and present them, that even if you don't agree with me, there are other ways of looking at this issue. And those all issues, if you look at them in this context, you will agree with me and find favor with me. So with this, at least, I will I will conclude on how I think court mannerisms have a role, and what aspects that you need to take care of. I would again highlight that always have at least a keyword index, speaker note, call it whatever, because in the end, like even I'm doing it right now, that I'm making points that I've already made and I'm ticking off, okay, this is done, this is done. That allows me to know that at this point I can at least safely say that I've covered what I really wanted to. And always recognize that the first thing that we discussed is that it's respect for not the person, but for the authority and the position that he commands. So I will hand it over to Aditya for it.
Hi, Afzal. I was kind of thinking about what all you were deliberating upon, but I'm sorry because we all only have this session with you, and this is the last commencing, last concluding session. So I'm also trying to get all the questions that I have for our students, or on behalf of our students. So if it's fine by you, and if you have that bandwidth of time, would you kindly, if you are kind enough to speak a word or two about rebuttal, because I
Sure.
think I missed out on that aspect, and I'm just
No,
putting
no,
on on you,
that's
because
something
that's
very
one of the aspect of oral readings which we normally don't discourse about, but I think it's
correct.
an important aspect. So I'm just, if for those and for those who don't who are not acquainted with the lingua culture of moot court competition, there is an aspect, or there is a part which is called rebuttal, wherein the opposite counsel is allowed to ask you questions or raise concerns regarding your submissions, and then you are also given a stipulated time to respond. So I think that's also a very integral part for a
Right.
panel of judge, because I was looking from the perspective of somebody who has judged a lot many moot court competitions. I was just thinking that that's also something that we as a judge look at. So if you
Right.
can shed a light on it,
So,
that would be really
so
helpful.
rebuttals are always helpful for making up for the lost time. However, again, what is the fundamental skill when you're talking about rebuttal is again the time constraint, because you're not given the liberty of 15 minutes. You'll be given some what 5 shy minutes to address your rebuttal. There is no fixed format. Some places have, some moot courts have a format where the other side puts these issues, or in some moot courts or the general moot courts, a rebuttal is granted once. If I am the plaintiff, the defendant has completed, I will be given a rebuttal of 5 minutes, defendant will be given a rebuttal of 5 minutes. So you generally at the rebuttal stage have had two things. Firstly, you've completed your submissions, so you are well aware as to which parts you weren't clear about, or at which parts the judges didn't seem convinced enough. That is point one. And the second is, you've heard the defendant speak, and you know what the defendant has said, at which point you think he's made an incorrect submission, at which point you think the judges have not resonated with him. And these 2 points you identify and hammer. Now the question is, because in 5 minutes, what all topics you cover, that can never be predicted. But it's always and always ideal situation that in that 5 minutes you cover two things. First, you reinforce something that you weren't so confident that the judges understood, but there has to be a point where you have to accept that I may not be able to convince the judge. So the best thing to do at this juncture is to reinforce something by putting down the defendant and trying to find chinks in his submissions, or find something that he wasn't able to successfully convince the court with. At that point, you take that and you hammer that argument again and again for the 5 minutes, so that even if you're not able to convince on your own merits, you're able to dislodge the other's case, so that you can at least lay some. It's always a good skill to see that somebody has been able to catch on something that was happening in court, and not something that somebody had planned or pre-planned, and use existing material to dislodge the other's case. That's always an attractive skill, or it's always good to see. It's always fun to see in debate somebody's points being cut down on the spot. So that shows the level of reading the other candidate may have done. So it's always good to identify in your own submissions what parts you think can be covered better, and second, identify what shortcomings the defendant placed in his own submissions or her own submissions, and use that to further explore the doubt that the judges may have at that point, and use that 5 minutes to address these two issues.
Great. That's very insightful, and thank you so much. I'm also thinking out loud and thinking out with you on it. I think there is one student who raised a flag that she wants to ask a question. So, Muskan, I'm going to ask you to unmute, and if you can go ahead and let us know who's from whom the question is, and either one of us will be more than happy to respond.
Sure, sir. Am I audible?
Yes, you are.
Any of you can answer my question. So my question is like, if we have 15 minutes for the oral rounds, sometimes it happens that the judges ask us a lot of questions, due to which we get limited time to complete all our arguments. So in such situations, should we prepare ourselves in such a way that we are able, should we prepare our speech for 10 minutes? Because it is for 15 minutes, but if we prepare it for 10 minutes, we will be able to answer the judges' questions as well, and we are able to keep up our arguments as well, or should we just prepare our speech in the way we prepare it?
Aditi, you want me to take it?
Yeah, I think
Yes.
let me add to what you say afterwards, but I would actually like to hear what you have to, because it's a very challenging question in that regard.
Certainly so. Muskan, as I said, it's having a speech is always a good thing, but recognizing which parts. So see, because your preparation span over a month, and I can tell you by experience, you'll not be able to distill it to a point where it comes down to 10 minutes. Even 15 minutes will feel not enough. My suggestion is, even if you prepare, I leave it up to you depending on what form or what format it is. Uh, Prepare based on the issues and allocate time to each issue, rather than not being satisfied with the entire set of the agenda should not be to cover all arguments in the 10 minutes itself to its completion. The idea should be that you prioritize arguments which need more time, which need lesser time. So the time allocation, as you said, may be for the entire thing, But what I would suggest is that have that time allocation on issue wise. Give it a bandwidth of, let's say, if there are 3 issues, then give it a bandwidth of which issue can exceed 5 minutes. If it's 15 minutes and there are 3 issues, you can ideally dedicate 5 minutes to each issue. And of course, in that issue, there will be questions back and forth. So what you can do is you can keep a period of 3 to 5 minutes for each issue, and recognize that in this issue I will not exceed 3 minutes, and in this issue, if required, I may take 5 minutes. My always concern is that you shouldn't go with a speech ready. The reason is that you should practice with a speech, you should definitely practice, but you should go with bullet points in your head, and that speech should be something impromptu, for the reason that when you start when you start your delivery based on a speech format, and if you're interrupted with a set of questions, and then you have to take up an issue again in a speech format, you don't know which issue you will take next, and it's an abrupt manner to leave um, your presentation if it's in a speech format in the middle, if there is a question back and forth. So it's always good to have keywords and recognize that this issue I will speak on these points for 3 to 5 minutes, and take assistance from your teammates. Have them prompt you that this issue has taken 3 minutes, this issue has taken 5 minutes. Use a mooting exercise is definitely a team exercise, so always take their help in identifying that if I have delivered on the first issue for 3 minutes, and you agreed that you will not cross 3 minutes for that very issue, including the time taken for questions back and forth, then you need to immediately switch to the other issue. So I wish there were an ideal answer for this, whether you prepare for 10 minutes or 15 minutes. My suggestion is you prepare for both. You have an extended version and a concise version, and you break the concise version into keywords and not contents, because I've never found comfort in somebody who looks at a text and continues reading. It's not engaging. And if you have a text, if you have a ready-made text in hand, you will definitely end up reading from that, and that's something that is not as a mood judge you wouldn't enjoy it as much. So my suggestion would be, even if you prepare a speech, but never look at it and speak. And never memorize it and speak on the spot, because you can only be prepared with, let's say, keywords and issues that may be thrown at you, and you respond to those issues based on it. If you have something to add.
uh, I think that's the reason as to why I stated that Muskan was a very challenging question, because some of the, from my experience as a person on the other side as a judge, is I am as a judge get very conscious if I ask reader question in between, because I can also see that they for them to get very disoriented and to get back to the issues is a major task. And and it's pretty evident sometimes, as you stay like you were talking about it. It's not let's not hesitate on addressing that elephant in the room, that as a judge also I would be very conscious if I'm stopping somebody in the or stopping would be a wrong word, intervening. And then I also see that students, students are gets disorienting while they, because they do have certain structure layout. We were harping upon how these signposts are important. What but one takeaway that I think I did not think about it, and I think that's a good way of practicing while you're practicing, is what Afzal was saying with regard to that. There should be a version which is much more extended, and then there is a parallel version which is abridged. I think that would Muskan would be something which should be a part of your mooting practices. When you are preparing, be prepared for the set of both the set of panel of judges, the judges who won't intervene in the middle of it, but then there are judges who will intervene. So I think that version, abridged version and extension, I know it increases, it allows you to transition much more quickly, because you also have to be very considerate about the time. I think if you, let's say, if you one thing that I would also add is, when you're responding to the judge's intervention, or when they're responding to the judge's question, I think students tend to over justify, and they play a lot around it, which effectively affects the other arguments, which might have a much more fundamental question to be asked. So I think do pay respect, as Afzal had been reiterating. Do pay that respect, but be cognizant of the same aspect that that pay respect to the question, not to the intervention. I think I might. There's another question, Muskan. I hope to a certain extent, I know it's not a very convincing answer that both of us gave you, but I think it will allow you to think in a bit more holistic way on how you can approach it. Go about this approach, that at least try the one which Afzal stated, with terms of preparing an average version and preparing an extended version. It will make you, it will, it will at least will make you have that confidence that you have two versions wherein you can shift the gears. There's another question, and I think that's a question for you, Afzal, because I would also, I think Sunani ma'am also taught legal English, so she might be in a position to chime in. But I think this is a question that you should,
Uh,
because you did mention about the colloquial language, and I was also very it's an interesting question. So I would ask you to yeah, let's hear
Certainly,
what you have to say.
certainly. This I think there's no straight answer to this. I One way to look at it is, why should it not be relevant? I am not saying that you have to use it, but so long as the principle is something that you cognizant of. uh, I think put in Latin terms makes it sound interesting, but the fact is, it's not knowledge of the term that people are looking for. It's the knowledge of the principle that people are looking for. For instance, a simple phrase or simple Latin maxim, audi alteram partem. That means that the other side ought to be heard, that you shouldn't pass any decision without hearing the other side. Now, putting it in a Latin maxim doesn't change that it's a principle of natural justice, that you ought not to pass any order without giving the other side due opportunity to present its own case. So it to say it in fundamental terms, it's not important that you know these maxims, but it's important that you learn these principles, and these principles originate from a maxim. So as I said, pay respect to the source, and this is nothing but the source. Indian law or Indian language itself, or Indian legal language, or the jurisprudence, evolved not in isolation. These evolved in the blessings, or in in constant scrutiny of English supervision, or our constitution is based on several constitutions from other nations. If our founders had the humility to accept knowledge or seek light wherever it was, why shouldn't it be the same for us as students, that we should seek knowledge and principles of knowledge of these principles from wherever they evolved? And I completely agree with Aditi that memorizing these maxims may not be the ideal, may not be the end goal that one is looking for. It's the familiarity and knowledge of these principles that is fundamental for you as a law student, for you as a law practitioner, because these principles are what shape a lot of the uncodified law. Natural justice is not codified in any of these statutes. Natural justice, principles of natural justice play a part in our in our judicial proceedings. They play a part in a whole variety of legal proceedings. So knowledge of the Latin maxims, of course, is a bonus point, if at all. But and I completely appreciate if anybody delivers the same principle to me in a standard language rather than a complicated jargon. I would That would earn my brownie points, regardless whether the maxim has been delivered verbatim or not. The points that we, or at least a judge, would be looking for or we as academics would be looking for is the knowledge of the principle and not rote memorization of the maxim on its own. Sonali ma'am, if you have something, please take it forward.
I think Afzal have already covered the point which I would like to say, that it is actually the principles which are not codified, and that's why we use them. So it gives a brownie points and relevant position. So I think I don't require anything to add on. But I would say that there's a question by one student, Rakshita. So she would like to know that, because they are first year students and they'll be doing mooting for the very first time. So how they should prepare a team, like how they should decide that who can be a researcher, who can be a presenter. So that's how they would like to know about.
Well, just to
Yeah.
add a little bit of contours to that, Afzal has never appointed me as his teammate. It's like he's consciously ignored me. When we were law students, he consciously ignored me for that, because he had inherent doubts over our intellect pursuits.
So I would let that slide. I will not engage in this discussion with Aditya. But coming to what Sonali, what the question is, I think how we, again, there is a different mooting format in every college. In Symbiosis, Aditya and I had a different format where our positions were basically a result of our performances. So we had an internal mooting round, which allocated points on speech delivery, performance as a speaker, as well as research and memo drafting. Now, based on these points, we were either eligible as speakers, or we were either eligible as researchers. So when we became a part of the team, we definitely didn't have a choice as to who would be a speaker or who would be a researcher. It's generally three people who recognize that one wants to be a speaker, who bid. We had a bidding system. So basically you were allocated ranks. Let's say I got rank 25 out of 100, and a colleague of mine got rank 24 as a speaker, both as speaker, and another colleague got rank 8 as a researcher. So the three of us went and bid for a moot, and we were allocated that moot based on our bidding ranks, and we were allocated as speakers or researchers. So I can't say as to what can be the bifurcation, because that was something that we didn't choose. But again, let's just come back to a situation where that hasn't happened. As teammates, and there are a lot of decisions that teams will have to take in testing times, in the heat of moot, you'll have to take a lot of decisions, and be mindful that all these decisions are taken as a team. As a team, you need to first, as your own self, be mindful of the skills that you have, uh, the what you can contribute to the team, and what is the best as attribute that you can bring for the team. That is something that you as an individual need to identify it first, that I am not possibly as good a speaker. My research skills are better, and I can better supplement people if I can assist them during the moot court. And a speaker should also be mindful that due respect to people who are not at the dais, because they have a better vision and better oral vision of how things are going, and perceive what is the reaction of judges in a more bipartisan way than the person who's delivering the speech himself. So it's always, as a speaker, you, if you decide or the team decides that you are the speaker, you need to be conscious that the people on the desk are with you, and what they're saying is not critical of you, is rather in aid of the team. So it's always good whenever a researcher, whenever a co-speaker passes you a note, it's always good to give it a constructive thought rather than looking at it with a critical mindset. And there are a lot of decisions that one team will have to take in due course of a moot, and how you go about it is something that comes down to identifying your own skill set first, and then recognizing that this is what I can offer to the team and offer before the bench. In that manner, you decide as to what is the order, because in some cases you will divide issues. Co-speakers will have to divide issues, and how you divide issues is from the very get-go. If you have a clear mindset that the particular focus of each individual is on a particular issue, that helps in course of preparation, that helps in course of delivery, and there is largely no friction if the outlines are set. And that's how an effective team works in any sport or any team event. To have clear demarcation of each other's roles is very important, and that discussion of each other's role has to be very open minded, has to be from the very start, and that communication between teammates throughout the mooting exercise is very important. So coming to that, also just to take Aditi's question once again, I forgot to mention one aspect. Memorizing Latin maxims seems like a task, but when you are practicing, when you read the same thing again and again, you become familiar with the sections. When it's okay to memorize sections, I I think it's, if you pay the same homage to the Latin maxims or French maxims, I don't think so you'll see it as a task. But when you do some activity too often, there is no requirement for you to memorize anything anymore. If you work on a certain set of provisions, when you're mooting, you will identify certain statutory provisions and you will read them time and again, and then you will not have to memorize that provision. Similarly, the same can be said about the uncodified law in form of maxims, that if you read something enough number of times for enough number of reasons, you will not have to memorize them and rote repeat it on its own.
Hi. Sorry, I was muted. I was talking. There's another question. I think it's a follow-up question from Muskan. So, Afzal, I'm going to read it for you, and just how to deal with situations when we are unable to convince judges with our arguments, or we don't have a proper answer to the question or the intervention that has been asked from us.
So
Like, I'm really sorry if we are taking a little
no,
bit
no, no,
of
I'm happy. It's a Sunday, so it's okay. So how this again comes down to the simple point that a moot is not the solution to a moot is not recorded in any of the gospels. You do not have one way or the or there is no other response to any of the moot problem. A moot problem always has equally weighing two sides of the same issue. It has weight on both sides, and that is something you need to be cognizant of. And it may happen that the judges come with their own notions about the moot problem, so it's completely fine if the judge doesn't agree with you. Nobody expects that the judge will stand give you standing ovation after your speech. That's generally not how it works. A judge is swayed or convinced by your research and your um, let's just say distillation of that research, because each question has to be answered, and that answer may not convince me, but that answer should still be there. I should come to a point, okay, I don't agree with this guy, but maybe there is some I like how he put these arguments, I like how he did the research, and how I like how he or she submitted the essence of their research and try to address an answer to my question. Now, that question, I may not be satisfied with the answer, but that's not what a moot judge is looking for. A moot judge is looking for how you handle that pressure of somebody asking multiple questions, and how you eloquently and in a sound researched manner provide an educated response to that. That doesn't mean that you don't answer at all, but at some point you answer and recognize that the judge is not convinced, and no judge will press you. You ask these questions, that once you finished providing with the answer, you ask this question, if it's okay, can I move to the next issue, if I have permission to move to the next issue. If the judge again asks, no, you haven't answered my question, then you answer again, and after that answer, again ask, again seek permission. That ways you're keeping the integrity of the proceedings and as well as moving forward in your presentation. And trust me, it's not a question of convincing one side that my argument is the only argument that makes sense. There may be other arguments also, but the fact remains that you've presented your front in a manner where I understood your argument and I disagreed with it. It's okay, but your point is not to convince me only. Your point is to deliver in a manner that I understand your point and complete your other submissions as well. So at expense of one question, because as I was saying, that there are often situations where students try to overcompensate their answer by backing it up with multiple points. And you've already understood that I'm not agreeing with you. You've already understood that I've understood your key argument. So it's upon you to move on. No judge will ask you to respond to a question more than 2 times. If you seek permission, saying that key after providing an answer, can I move on to the next issue? Do I have permission to move on to the next issue? Any judge will agree. He will make note that this is what the answer provided by you, and you may or may not get points for it. But fixating on one issue and letting go of other issues which you can possibly convince me of is not a good strategy in any way. So you need to pick and choose your battles. That's the key.
Uh, Thank you. That's very insightful and very pragmatic. Just to add, just to add to what you stated, I think what would coming from a very different strand of thought, but I think Muskan, to respond to your question in a much more theoretical way, would I don't know if maybe maybe ask what are the virtues of the moot court competition. The virtue, when you will ask that question, what are the virtues of moot court competition, you'll also be able to unpackage or at least unpeel what are the virtues of a judge who is sitting on as a panel, and it might be see, an ideal moot proposition will have that ambiguity that there is no perfect answer. There's no, that is how it is meant to be made. So maybe the intention or the virtue why judge is invoking or intervening is to have a certain dialogic discourse with you. Pay respect to that dialogic discourse. Don't hinge on to the aspect that okay, that your response is the deal breaker or be all and end all. Engage with him or her in a capacity, because that's why I kind of started with that it might sound very theoretical, but maybe the entire virtue or the telos of moot court competition is empowering you to have that dialogic discourse. So I think that's gonna be my take from it, that be respectful as Afzal stated as well. But at the same time, it is not your objective to make sure that judge is convinced by your response or not. That is not your onus to take. And the reason why, again, as to why I'm elaborating so much on it, because I've seen students, especially participants, getting discouraged by that linkage that, oh, judge is not getting convinced. It's not that, okay, if you are, let's say, appearing for the appellant, and if you win the case for appellant, will give you a reward in terms of moot court competition. It does not really matter whether your client wins or loses. The virtues that they are going to be testing you on, how you engage with them. I think that's gonna be it from my end. Sonali ma'am, do you have anything to add? Or do we have more questions?
No, I don't think that we have any more questions.
Okay. So let me provide a quick vote of thanks to Afzal Badr Khan. Thank you so much for spending this time with us on Sunday. Hopefully, we would be having more sessions with you. We would be more than happy if you come and visit our campus. It's a beautiful campus. It will provide you some refuge. There's a lot of foliage, so some refuge from your Delhi city life. Our students will be more than glad, and I think will be more than happy to have you as a mentor for some of the ventures that we are planning as a Moot Court Society to do. So again, thank you so much, Afzal.
Thank you so much for
being
having me.
part
It
of
was a
us.
delight. Thank you so much.
Thank you. Just a quick
Thank you so much for joining.
Yeah.
Thank you, sir.
Just a quick announcement for those students who are there in the class. We have a Moot Court Society in Amity, which we are trying to reinvigorate so that it can allow you to participate. It empowers you, at the same time enables you or helps you in any sort of capabilities, whether meant, because over the workshop, there are a couple of things that we realized. There are a couple of learnings as a faculty as well, that we need to be much more coordinated in our efforts when we are supervising any Moot Court teams. There are efforts which are not coherent. So we are reinventing our Moot Court Society. We have two student heads who are also the coordinators for upcoming Moot Court competition. I am going to ask them if they are here to open up their video, introduce themselves, and let us know about some of the things that they have planned, which are still in a pipeline. But I think since most of the students are first year and second year law learners, they will be more than happy to hear about what are some of the ventures that we are planning as Mission 2022. So do we have Dipesh and Harshvi with us? Dipesh,
I think if we can ask Lalit sir to make Dipesh and Harshvi the co-host, so might be they will have the. Lalit sir, am I audible to you?
okay, Harshvi is there.
Yes,
Dipesh
ma'am.
is-
Yes, ma'am.
Yes, sir.
Thank you, sir.
So Dipesh, why don't you go first and then Harshvi can jump in, or you can take it together. So the floor is open for all of you. Yeah, just take it
Sure,
over
sir.
from you.
Thank you so much, sir. Thank you so much, ma'am. So hello everyone. I'm Deepesh Kataria. I'm a fifth year law student, like from Amity Law School. My stream is BCom and LB honors, and my specialization is in corporate. First of all, I would like to thank Ashu ma'am, Aditya sir, and Sunali ma'am for giving us this wonderful opportunity to be the heads of our Moot Court Society, Moot Court Society that we have, re-established. So this was the first of many events or many workshops that we have planned to, inculcate mooting culture or to reignite the mooting culture in our law school. And also we are organizing this Amity National Moot Court competition online, the second edition of it, but under the Moot Court Society, Amity Law School Jaipur, which is being organized in 8 to 10th April 2022. And also there is also an event plan, like an intra Moot Court competition. It is still in pipeline and planning, but it will help the students to, have an brief about or have a rough expertise on the how the moot court competition works before actually entering into a competition. It would be an intra that is between the students ourselves. So I would like over to you, Ashwi.
Thank you, Dipesh. Hello, everyone. My name is Harshvi Chauman, and I'm a fifth year law student at Amity University, Rajasthan. I would like to thank Sonali ma'am, Aditya sir, and Ashu ma'am for giving us the opportunity to be a part of the Moot Court Society head. And as already Dipesh has briefed about the Moot Court competition, which we are organizing in the month of April from 8th to 10th April. So we would love to see students participating and helping us out in our various committees, organizing committees, and would also be happy to see people making a good utilization of this Moot Court Society and asking faculties and students for the help for their further Moot Court competitions. Thank you so much, sir and ma'am.
Okay, I have just a quick question, not a question, but since these are the students that we are targeting that they will be participating in the near future, why don't you both of you tell a word or two about how moot experience, what kind of moot experiences you had? Like we'll start with Harshvi, since I can see her. Harshvi, how about your moot experience? How has it been? What did you learn? What is there for law students in the moot court competition? And you can talk in a much more casual language. It's okay. These are
Yes,
our
sir.
students.
Since when we participated, everything went online, and we did our moot court competitions. I participated in 2 moot court competitions, and both were online. But there's no difference between online and offline. It's just the virtual thing that makes the difference. Otherwise, the grilling that the judges do is the way they do it when we are present there also. But it's a good experience, and it gives you a good speaking skill as well, because most of students are not comfortable with communicating and everything. So once they started participating in moot court competitions, they are very good enough to put their point through. And I think this is the best platform for the law students especially, and for the students who are very introvert and can't speak enough in front of everyone, because most of you are interested in writing research papers and everything. That's a good thing also. That's also helps in good research and everything. But moot court competitions is also very important for a law student in their career.
What about you, Dipesh?
So apart from online, I've also been a part of, Manipal Ranka National Moot Court Competition, like just a year, just 6 months before everything turned off and we went into pandemic. So my experience of that physical moot court competition, like going there and presenting, meeting so many teams, and when you actually interact with them and you get that memorial, you are there, and you have to check that memorial, you have to vet it, and you like that experience that with your team that you do, and then you get to know that these were also the research points that you have seen. And when you actually be there physically, you get to much more it's much more the vibe, or like, how can I put it, like the actual moot proceedings that actually happen, like you feel that yes, you are standing in a court of law. But that's where we stand a bit like restrained in virtual platforms. So it's really nice experience when you have your team members, with your team members, they might be your friends, or your classmates, seniors, juniors. So that team, and you have a different experience there. And yes, that's it from my side.
That's wonderful, both of you. Thank you so much, Dipesh and Harshvi. The reason I wanted you guys to speak, because since there is always a hierarchy when a faculty is speaking. I wanted all of you who are right now present with us, all the law students, just a concluding part, or just a concluding statement, that the intention of doing this workshop was not to tell you the complexities associated with moot court, but was to tell you, or to instill that thing, that moot court competition, along with its prestige value that they provide to you as a law student, is one of the most empowering exercise. It, as you know, Harshvi was, and I'm just going to take that cue from Harshvi, because Harshvi did mention that it allows you to open up. It allows you to think, to talk, to create some things which you might not in your comfort zone create. So I think that's one thing. And so please be proactive. See, I asked them to open their videos also, because you know them, so that you can ask all your questions to them. If you don't, if you are not really confident with us as a faculty members, these seniors they're bound, they should help you out. Ask them those questions, which moot is to go, which, ask all those logistics questions, because they are much more somebody who are coming with a very recent virtual, and as Dipesh mentioned, offline experiences as well. Grill them, empower yourself by asking all these questions to them. Have that flow of communication. We'll be I think we will be as I stated, we'll continue to host certain things, some certain institutional things like workshops and everything. But apart from them, I also expect all of those learners who are there in the class today, just reach out to MCAs. To reach out to MCAs, they can guide you. We will be more than happy, as a faculty or the student convener, we'll be more than happy to guide you in your preparation for any sort of moot court competition. But then the only expectation is that let that be a two-way transparent topic. Allow us to be a part of your journey in that way. I think that's a fair enough statement that I made. Sonali ma'am, do you want to add anything? And just let's conclude it. It's all. I can see that students might be like, oh, it's 12:30.
No, I think then we can conclude rather than making it any more lengthy. And yes, so as you said that we have the Moot Court Society, and anyone wants to connect, they can connect with us or they can connect with the students for any kind of information detailing. But I think that's all from my side. So we can conclude the session today here.
Great. Thank you everyone for attending it. Thank you so much for being here on Sunday. Now you can have all happy Sunday. We'll see each other on Monday. Thank you everyone. Bye.